Your Honour, following on from my learned senior, I will now move on to Submission 2, Duty of Care, which will be followed shortly by Submission 3, the Scope of Duty. It is respectfully submitted that the Quigsley Hotel did not owe the plaintiff, Jenna North, a special duty of care in relation to her falling and injuring herself within the premises and claiming to have slipped on a coaster that was nearby from where she fell. Whilst it is only a general duty of care, this does not mean that a higher standard of care exists or is required. Although the plaintiff may argue that a higher standard of care is required by venue holders, it was held in Coles Supermarkets Australia, Pty Ltd, vs Magnacello 2013. The plaintiff has the onus of proof and must establish all elements of a negligence claim on the balance of probabilities, upon which, if this cannot be determined, the claim will fail. Counsel for the defendant also submit that the standard of care cannot be established with Strong v Woolworths Limited 2012, as Justice Hayden dissented on the basis that the plaintiff had the legal burden of proof and failed to establish on the balance of probabilities as to what time the dropped food which caused the slippage occurred, and if in fact it occurred before the increased cleaning schedule was implemented around the busy lunchtime rush. This failure to establish on the balance of probabilities that the food which caused the slippage had been on the walkway for some time is as much the same as the coaster Miss North claims to have slipped on. The lack of a duty of care to Miss North by the Quigsley Hotel is further affirmed in the decision of Kosh vs S.E. Dickinson, Pty Ltd, whereby Justice Haynes suggested a factual circumstance in which reasonable care required the occupier of premises to carry out inspections at regular intervals throughout the entire business hours. The Quigsley Hotel staff reported that the bar attendant had done a walk through the area only a short 30 minutes before the incident of Miss North's fall. It is arguable as to when the coaster was in fact dropped, or in this case, if it was even slipped on. Pause it. Counsel for the defendant also submits, although a licensed premises has obligations to patrons pursuant to the Liquor Act 1982, New South Wales, it remains law that the liability of licensees will depend on a plaintiff establishing that the licensee ought to have known of facts requiring a direct intervening act, which would have safeguarded the injured persons from a foreseeable risk of harm, as seen in Adil's Palace, Pty Ltd, vs Murrabak, and also Adil's Palace, Pty Ltd, vs Bojnaram. As the hotel is usually a quiet, family-friendly facility, the security personnel is not considered to be a necessary need, with adequate bar staff present at all times of service. According to reports, no visible aggression was witnessed by the hotel staff. The effect of this finding in Palace, Pty Ltd vs Murrabak by the High Court of Australia was that the absence of security personnel at Adil's Palace on the night that the plaintiffs were shot were not a necessary condition of their being shot, and thus the but-for test of causation is not satisfied. In conclusion, as stated by my senior in Submission 1, that as it has been put forward to the court, it can be determined that due to the nature of criminal conduct being unpredictable, it is unreasonable to place such foreseeability onto the plaintiff. It is also unreasonable to place a duty of care onto the defendant for such behaviour that occurred to the plaintiff by a third party. When considering the case facts of Wagstaff vs Howland, it is unreasonable for the proprietor to treat every intoxicated individual as a significant risk. As evidenced in Submission 2, Coles Supermarket Australia, Pty Ltd vs Magnacello 2013, a plaintiff has the onus of proof and must establish all elements of negligence claim and the balance of probabilities, upon which, if this cannot be determined, the claim will fail. Further affirmed in the decision of Koch v. S.E. Dickinson, Pty Ltd, the regular checking of the area for any dangers was carried out by the bar staff an adequate 30 minutes prior to the incident occurring. And lastly, under the Liquor Act 1982, the liability of licensees will depend on whether there was a foreseeable risk of harm and how the licensees dealt with this. It is reminded that no prior displays of aggression were witnessed by the hotel staff. And finally, with submission 3, it is evident that the scope of duty of care has been determined based on cases with the same circumstances and situations. In conclusion, it is clear that the relationship between Miss North and the defendant Quigsley Hotel do not constitute a breach of standard of care. Thank you for your time, Your Honour.